we try to make it a weekly podcast to update everybody on Heather's case. Sometimes life gets in the way.
Yeah, so today is Thursday, October 2nd, 2025. Our last episode was on September 15th on my daughter's birthday. Pete, you want to explain why we haven't gone live?
Well, right after that, I ended up getting sick and ended up in the hospital. Very much unplanned, unwanted. Basically, the doctors in the ER, all the scans showed a what they call a small bowel obstruction, meaning something's blocking your small intestine, or it's twisted or kinked or went somewhere where it's not supposed to go. And the way they treat that, they put an NG tube in your nose all the way down to your stomach, try to vacuum everything out, and then just give you time. Hopefully everything resolves on its own, which is what we thought happened. So I went into the ER on a Thursday. I was discharged from the hospital the following Saturday, so I was in for 4 days. And then we came home, and I go to take some drinks of water or Gatorade, apple juice, and I could not keep anything down. Everything was not staying in my body, which is a problem because I was already dehydrated from the first couple days. So Sunday morning, we went back to the ER, and they readmitted me. Basically, we had to start over from square one, and then I ended up being in the hospital for a week and a day after that. So Sunday all the way through the following Monday, and things just were not progressing early in the week, and they decided to do a sort of emergency exploratory surgery on Thursday. So I'm cut open from like here down to just under my belly button because in the process of doing what was supposed to just be a laparoscopic exploratory surgery where they go in with 3 small incisions, they ended up poking something they shouldn't have, and so they had to cut me open to repair that. So I'm still pretty sore, but I'm definitely getting better. I'm definitely able to eat and drink again, but we're taking it slow and one day at a time. So. Yeah,
it's definitely been an interesting last 2 weeks. That came on so suddenly, and it was so urgent that he needed to go to the hospital, and that's where he remained for several weeks. So tonight we're going to be discussing my Illinois case and the upcoming hearing on October 8th, 2025. So in episode 16, which was August 12th of 2025, I introduced to everybody on my podcast my petition for relief in Illinois Circuit 19, the court that started all of this in 2020, that stole my children from the daycare, put a gag order on me, took my children's cell phones away, cut off all forms of communications with me, trafficked them for a year in Illinois foster system, and then sold them to the non-custodial parent, Justin Serlick, in Daytona, Florida, and then shipped them down like pieces of property August 11th of 2021, where he has been holding them hostage from me since. So we are going on over 4 years since they've been down here in Florida. I've been down here since December of 2021, so there is absolutely no excuse for me to not be able to see my children, other than Justin Serlick holding them hostage and demanding ransom. So while we've been fighting this in Florida Circuit 7 since August of 2023, I decided to educate myself on what remedies I would have in Illinois since they started this mess with the 3-page order that Marnie Slavin signed April 27th of 2022. 3 pages, ex parte, void ab initio, completely illegal, violating a plethora of my constitutional rights, my children's constitutional rights. And there was absolutely no due process because it was ex parte. I was not privy to any of this before it was signed.
Yeah, and not only, you were never served properly with it. They conducted the hearing without you even being present.
Ex parte.
They didn't even officially serve you a notice of the final order. You ended up getting that because your ex-mother-in-law, after your timeline to appeal, she then emails it to you with a very nasty, gloating email.
Gloating, yeah. So there's not even a certificate of service on it. There's no proof whatsoever that I was ever served with anything prior to it being signed or after it was signed.
Which, as a somebody that new coming into this, I wasn't part of Heather's original family case. I'm not really part of the case. I'm just here to support Heather.
Tiger.
Seeing, we thought there was, corruption happening in the Daytona courthouse on a number of levels, but some of the stuff we've seen happening in her docket in the Illinois Circuit 19 is just, it would blow your mind. Aside from, things not having certificates of service to prove that they were actually properly served to people. He's got to get off the table. He's going to knock the camera down. Things are showing up weeks and months later and then being backdated as if they were filed, the same day as something else.
We're going to get into that. So we are discussing today, we're going back to when about a month and a half ago, we had stopped doing this, where I was literally breaking down my entire docket and then scanning it and providing a Google Doc link for you to click on these documents and read them, save them, distribute them, share them, whatever you want to do with it. It's public record and you have my permission because they're my documents. So these are already scanned, and I will be putting the Google Doc link in the podcast description like I was doing before. So we're going to focus on Illinois, and then at the very end we'll quickly touch on what's happening with my Florida Circuit 7 case, because that's interesting too. So document number 1. So this is in chronological order. Everything after my petition for relief, which is over 300 pages. The link for that is in the episode 16. However, I will also be providing the link in this episode for the petition itself. It's over 300 pages, so it's one big document. So I'm going to keep that separate. But the original petition was filed in July. And then we had the very first hearing August 12th. And then this was entered August 12th of 2025 after the hearing. This cause coming on before the court for presentation of petitioner, me, verified petition for relief from void judgment and for declaratory relief based on lack of jurisdiction and due process violations under 735 ILCS 5/2-1401F. It is hereby ordered, respondent is granted until, and that would be Justin and his attorney, is granted until August 26, 2025 to file his motion to dismiss and the presentment of respondent's motion to dismiss, status on the pleadings, and the setting of hearing dates for respondent's motion, blah, blah, blah. Parties are advised that the court conducts hearings in person. Pete, what do you notice about that last part there?
So the very last part here, item number 3, it was added after the fact. So this is somebody at the court or the judge herself, just adding a provision that she wanted added to it.
And it's a different font?
Different font, probably a different size. This is, everything else on here was typed in like Times New Roman font, and then number 3 is Arial.
It's so obvious it was added after they signed it. So,
well, not necessarily
manipulation
after,
continues.
not necessarily after it was signed, but the proposed order that was, so in Illinois, the attorneys have to submit proposed orders to the court. So in this case, Justin's attorney submitted the proposed order based on information from the hearing. Information from the hearing was just points 1 and 2. The proposed order goes to the judge, and then somebody, either the judge or their judicial administrative assistant, whatever, just adds another line. Oh, parties have to be in person.
Yeah.
So
they're requiring me to fly from Daytona, Florida to Waukegan, Illinois for a mess they started.
Which is just something to point out. This is just the judge's personal rule for her courtroom. The Illinois Supreme Court actually has what they call Rule 45, where they've basically instructed all courts in Illinois, if it's available to have a Zoom hearing to save money and save time and save energy, they're required to have Zoom hearings. So this is the judge blatantly flocking the Rule 45 of the Illinois Supreme Court.
It is absolutely on purpose. So then after that, we have the minutes Very brief. Jacqueline D. Melius, my judge. Present in court, Heather Bendl. Petitioner present via video. Attorney Will Traberis, present via Zoom. That is Justin Serlick's attorney from the same law firm that actually wrote and presented that 3-page order April 27th of 2022.
It's weird that they would say you're present by video and then the attorney's present via Zoom when you're both present via Zoom.
Mm-hmm.
So it's,
yeah.
why the change? Why difference?
Nature proceedings, event result heard 8/12/2025. The matter is set for status on 9/2 at 9 a.m. in courtroom 105. Order entered. All right, so that was August 12th, the day of the hearing, that very first hearing. And then August 14th, I file a response. Now, I am fully aware that these responses really don't have much weight, but what it does do is get everything on the record.
Yeah, and this was sort of a preemptive response because in that initial hearing, Justin's attorney made a comment that he was going to be filing a motion to dismiss.
Mm-hmm. So the title of it, and it's about 12 pages, so we're not going to go through the whole thing, but this will be available to read. But the title is Response to August 12th, 2025 Order and Notice of Illinois and United States Constitutional Defense. So this is me getting everything on the record and saying, if you continue to violate my constitutional rights, my Illinois constitutional rights, my federal constitutional rights, you're going to be subjected to a 42 USC 1983, 85, and 86.
And one of the reasons Heather specifically put that in writing is because in that first hearing, Heather made a comment that, she would potentially sue the court and the officials. And they tried to pose that as if Heather was making a threat, when the reality is it's actually protected speech.
Mm-hmm.
It is somebody petitioning the court and just identifying to the court that they will take any and all legal remedy against the court officials.
When state
courts are not
judges,
allowed to deem it as a threat.
Yeah, when state judges violate our constitutional rights, what is the remedy? The remedy is federal court, civil rights. That's why 42 USC 1983, 85, and 86 even exists. It's to keep it in check and balance so the states cannot trample all over your God-given rights as a U.S. citizen, your unalienable rights. It's in the Constitution. So after that, August 12th, that same day, is the response. Respondent is granted until, actually, no, that's part of the exhibit. I'm sorry. So that was the response, and then the exhibits after that. And then after that is the notice of motion on September 2nd, and this was filed by Justin's attorney, August 22nd. So now we're on August 22nd.
Now, something important to note at this point when he's filing stuff, and he's already appeared, there's still, even to this day, no notice of appearance filed into the docket of the current open case. 20F422. 20 stands for 2020. That's when I reopened my 2013 divorce case. And F stands for family. And then 422. He filed his notice of appearance into my old 2013 divorce. So
that has nothing to do with this current case.
So it shows up in that docket,
but not
the current one. Now the judge is just like, oh well, he listed both cases on that filing.
Doesn't matter. It's not my docket.
Here's the problem: when this goes to the appellate court, there's no record of him being part of this case,
and that's what they want.
They're getting away with literally hiding stuff, and it's so asinine and simple. Just file it into the right case.
Mm-hmm. Yeah.
How hard is that?
It is absolutely docket manipulation.
Heather has brought it up multiple times, and they're just flat out ignoring it as if it's normal practice to file your appearance in some random other case.
Yeah.
Just because on that appearance you listed this other case, everything's fine, but it doesn't show up anywhere for this open case.
Yeah, it's crazy, but they think they're trying to be sneaky, and they think they're trying to fool us. And I am a very, very, very OCD. I pay attention to every tiny little detail. So that's why I'm getting everything on the record. So when I do go after these criminals in federal court. Everything's on the record. They're trying to keep everything off the record, and I am requiring everything to be on the record. So August 22nd, they file. On September 2nd, 2025 at 9 a.m. or at any such time after this matter shall be heard, I shall appear via Zoom before the Honorable Jacqueline D. Melius or any judge sitting in her stead in courtroom number C-105 at the courthouse for the 19th Judicial Circuit, 18 North County Street, Waukegan, Illinois, and present the 2-count motion to strike and dismiss petitioner's verified petition for relief from void judgment and for declaratory relief based on the lack of jurisdiction and due process violations, a copy of which is hereby served upon you. Now, here's the other thing. They're not even serving me properly. I put on the record that I will only accept service of documents through Illinois e-file Odyssey portal. They are not to direct email me anything. I'm done with the off-the-record emails. That's how all of this began.
Yeah.
This same law firm, Will Traveris' law firm, was emailing orders directly to Judge Morosin and Judge Marnie Slavin, and they were just getting signed without me.
Nothing was actually being filed through the clerk of the court and being docketed. It was all just them emailing motions. I mean, the actual docket prior to Heather recently filing in Illinois Circuit 19 was only 30 entries total from the start of this case, which was Heather trying to modify her original divorce and child custody because they had a fourth child. 30 docket entries was the totality of the docket, and most of those were just continuances.
Well, yeah, because I had rehired my divorce attorney from 2013, Dennis Gravel of Gurnee, Illinois, June of 2020, after Justin said, I'm moving to Florida, I'm moving in with my parents. And I said, okay, great, bye. The kids and I are staying up here in Illinois. And I rehired Dennis Gravel to modify our 2013 for several reasons. To get my youngest son, Charles Serlick, listed onto the parental agreement because from 2017 to 2020, other than his social security card and his birth certificate, he didn't exist in the legal documents. So he needed to be added in to be covered under that parental agreement. And then because Justin was choosing to move down to Florida and leave his children up in Illinois during the pandemic, after he chose to make us homeless, I was like, okay, fine. You're going to move more than 100 miles away. We're going to update the child support. I've never filed for a child support modification since our original divorce in 2013. He was making $16 an hour when we got divorced. He was working for Intuit. So was I. We were making $16 an hour. So his child support was based on $16 an hour income and 3 children, with me having primary sole custody. I had 100% sole custody in that divorce. So in 2020, he was making $65,000 a year for Konica Minolta, all covered, as a level 3 help desk engineer. So obviously that's way higher than $16 an hour. So 4 children at $65,000, and you're moving more than 100 miles away from them, meaning you're no longer going to be a full-time parent in their life, we're modifying the child support. So that is how all of this began in June 2020.
And this, basically you filed this, and then all of a sudden, out of the blue, there's reports going to Illinois DCFS, and they show up and snatch the kids.
Well, the kids and I came forward in regards to the abuse through a safe place in Waukegan, Zion area of Illinois, in Lake County. And the counselors my children and I were seeing in regards to that abuse afflicted upon them and what he was doing to me, had said, you need to hold him accountable. Go to the police, file police reports, have the children give the recorded interviews for the child abuse, and have them charged. So we did that. 2 weeks after the children were interviewed, Tommy and Bianca were interviewed at the Child Advocacy Center with Michael G. Nurheim's name on the building in Gurnee, Illinois, where he also lives. Everything's linked to Gurnee, Illinois. They were taken from their daycare October 8th of 2020. So we are coming up to the 5-year anniversary, and the next court date is on the 5-year anniversary of my children being kidnapped and then disappearing from my life. So back to this. So August 22nd is I want to say it's like 12 or 20 pages of the 2-count motion to strike and dismiss petitioners. So basically they're motioning to dismiss it. Okay. So that will be there for you to take a look at.
And a couple interesting things about that motion to dismiss. When we got that, the argument that they're trying to dismiss Heather's present motion
there's no jurisdiction.
Is that there's no jurisdiction because everybody lives in Florida. Now, the timeline he gave in that, we agree with. Mm-hmm. Nobody was in Florida when the April order was issued.
No, everyone was in Florida and no one was in Illinois.
That's what I'm saying. Yeah, sorry. Said it backwards. They basically agree with the timeline that nobody was in Florida. And if you actually follow the rules of the UCCJEA, the time everybody was in Florida when the determining precipitating events were, the reality is it basically confirms that Illinois didn't have jurisdiction. And he's trying to say they don't have jurisdiction now.
But they made a custody change, a complete 180 of what the custody was in that April 27, 2022 order.
More than a 180-degree change because the original your original custody, you were the sole custodial parent, but Justin had visitation.
Right. Yeah, and I have nothing.
And for years after your divorce, you guys, he was still living in your house, even though you were not together as a couple.
Up until February 28th of 2020.
For years, even though he was only on paperwork as having visitation, he had 100% time if he wanted to.
Yeah, he was living with us. For all intents and purposes, everyone thought we were still married, which... for me, made it almost impossible to have a relationship with another man after I divorced Justin because he was right there. So August 28th, I file in response to the 22nd, verified response in opposition to motion to strike and dismiss petition for relief under 735 ILCS 5/2-1401F.
This is basically the direct response to
getting more stuff on the record.
Justin's attorney's motion to dismiss. This is basically just saying we completely object to that motion to dismiss for all of these reasons. And basically the reason is the Illinois Circuit 19 was the original court that issued this order back in April of 2022. They still retain limited jurisdiction over that order.
Because they signed it.
They are the only court that can actually deem it fully void.
I've already tried to have it dismissed here in Florida.
Well,
I filed a motion to vacate in Florida Circuit 7. It was slapped with a denial within hours. I turn around and file a motion to appeal or a notice of appeal, and then we go through the Florida 5th District Court of Appeal, and they completely dismiss my appeal because they don't have jurisdiction to vacate it. So what did I do? I went straight to Illinois. Okay, if Florida doesn't want to deal with it, I'm going straight to the courthouse that made it.
Now, the reality is the laws, you have to follow the laws, and everybody in family court knows the judges don't follow the laws. They just make stuff up on their own. Mm-hmm. It's like, when anybody's playing Monopoly, everybody plays Monopoly. Everybody's got different rules about what you do with the money that gets put on the center of the board and what happens if you get in jail or get out of jail. And the judges make up their own rules with this stuff. So if you were to actually follow the rules, the Florida courts can deem the Illinois order void and unenforceable.
Yeah. Yeah.
But if Heather were to go back to Illinois, that court could still say, oh no, it's still a valid order. And so then you have conflicting orders across different states.
Yeah.
So this is an effort to just unify everything and clean it up and be able to try to move forward.
This verified response, that was August 28th. So the next hearing after that was September 2nd, and that was via Zoom. And were any of my court watchers able to court watch?
I I would have been the only person, and that's only because I was sitting next to you. If I was actually on a computer trying to log into it, they would, as soon as they saw that I was trying to be there for the case of Bendl versus Serlick, they would have booted me out, because that's what we watched happen. We had multiple of your court watchers
systematically kicked out as soon as they said they were there to court watch for me.
Multiple court watchers live as it was going on were messaging you like, "Oh, they just kicked me out."
So that hearing was interesting, but Judge Melius originally said that, so Will Traberis argued that Justin Serlick doesn't have the means to fly to Waukegan.
Because it would be a burden, because he's a sole parent to 4 children. And
so I said, okay, fine. Well, if Justin's going to be remote, then I have every right to be remote. He does not get special treatment. This is my case against him. He is the one holding my children hostage, and he is the one causing me to even file this in Illinois Circuit.
And the reality is, Justin's taking care of the 4 kids. But that's because that's been his choice. He's blocked Heather from having any part of their life. Heather, how many students do you have?
I now have, because my classes were reduced because we got a 3rd teacher, I was at 243 9th, 10th, 11th, and 12th graders.
So at the time of this hearing, you had 243 students.
Yes, I did.
That you were responsible for.
Yep. And it originally started out at 251, but they did some schedule changes. But yeah, when I originally started at my high school as a marine biology teacher, I originally started with 251 freshmen through seniors. And then they pulled some because they realized that's just way too many for a brand new teacher.
They reassigned another teacher from the middle school that lost enrollment.
Yeah.
And so they expanded it at a couple class sections.
They pulled students from both of the other marine biology, my mentor and myself, to lower our class volumes. And now I'm at 183 students, freshmen through seniors. So I'm responsible for teaching marine biology to 183 high schoolers, but I have had 0 contact with my own flesh and blood, Ariana, Thomas, Bianca, and Charles, since pretty much Illinois shipped them down like pieces of property to the non-custodial parent August 11th of 2021. So this order says, and this is also been typed up, I think, by Traberis, because he said, would you like me to get that typed up for you? Sure. So, this is my case. I triggered this with my petition, and here they are controlling my case.
But I mean, that being said, this is honestly just stupid busy work, and it's honestly, it's the court being lazy and not just having somebody there to record what happens and saying this is the order of the court.
Yeah. So the date and the time are key on this. Okay, so filed September 2nd, 2025 at 2:07 p.m. And it says, it is hereby ordered, as petitioner has already filed a response, which we already went over, on August 28th, Respondent's 2-count motion to strike and dismiss petitioner's verified petition for relief from void judgment and for declaratory relief, blah, 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 and other relief is set for hearing on October 8th at 9 a.m. in courtroom C-105 in person. And then right after that, it says, in the same font, in the same line, parties are required to appear and may attend via Zoom. Make it so. Okay? That's what was discussed in that September 2nd Zoom, where I argued, okay, well, if Justin's going to be remote, so am I. Yeah, and she said, fine,
and the judge,
so be it.
In the hearing itself, the judge acknowledged that it was going to be a financial burden and hardship for both Heather and Justin to actually travel to be in person in Illinois. And the reality is, with technology these days, there's no reason to force somebody to be in person unless
you're doing something nefarious,
which we kind of have a sneaking suspicion that they might be.
Mm-hmm. And that's why we're getting it on the record. So the whole world knows exactly what's about to happen.
So that first order was filed at 2:07 p.m.
Yes. So nothing happens in my docket after that. until September 23rd, randomly out of the blue.
So more than 20 days later.
21 days later, I get a blank email. I mean blank. No subject line, no body, nothing. Just a blank email.
From somebody at the clerk.
From Iris. Let me give you her full name because we're all about transparency. Lake County, Illinois, Circuit 19 Clerk Iris Salcedo, Salcedo. Email address isalcedo @lakecountyil.gov. So I get this blank email from her, and the email will be in this scan. And I get this blank email from her with this.
This was attached. So an attachment. So if Heather didn't notice there was an attachment, it's just a random blank email. It could have easily been deleted.
Yeah, absolutely. Could have gone to my spam folder, whatever. So this has a date of September 2nd at 3:12 p.m. 3:12 p.m.
So barely an hour later.
An hour and like 6 minutes later, another order is filed. Now, I don't think this was actually filed into my docket on September 2nd, because if it was properly filed, I should have been e-served, because that is what I am requiring them to serve me with. So if they think this is proper service, they're out of their damn mind to send me a blank email with no body, no subject, and just this one-page order in it, backdated to September 2nd. And this says, this matter coming to be heard on the court's own motion, the matter being up earlier in the day, it is hereby ordered, 1, Miss Heather Bendl and Will Traberis are ordered to appear in person in C-105 for the October 8th, 2025 motion to dismiss hearing date. 2, Heather Bendl's Zoom privileges are being further reviewed, but have been revoked for the purposes of any and all hearings. Ms. Bendl's failure to appear in person will prevent her from being able to make any arrangements at the scheduled hearing date. Make any arguments at the scheduled hearing date. It does not say Justin Serlick is required to be physical, just that me and Will Traberis are.
Yeah. So this is even if we, at this point, if we were to retain an attorney, which we're talking to a few, but if we were to retain an attorney, this is written almost as if you are still required. We have to put you on a plane on Tuesday.
Mm-hmm. Yeah. And there's more docket manipulation in this too, because take a look at the case numbers. I didn't notice that until just now.
Different font.
Different font again.
Literally a different text size.
Different font, different text size. Why? If they're typing this all up in the moment, why add to it? And even this final sentence is different font.
Let me see. Yeah.
Look closely at it.
Yeah, it is smaller. That's literally.
So you're telling me that someone is sitting there typing up the order and changing the font before they go to the next sentence?
This is modified. It's going through multiple people, and they're just adding their own stuff to it. And then, of course, it's just e-signed by the judge, so that it's not a real signature. It's
auto pen.
It's basically auto pen. It's modern day auto pen.
Yeah.
Everybody got mad at Joe Biden for doing it, but friggin' judges can just click a button on the computer and their signature just gets stamped on it.
Yeah. So then we have the minutes from September 2nd. Clerk Iris S., same clerk that sent me this blank email with this one-page order with absolute modifications on it. Just look at the text, look at the font, look at the size. It is so obvious that someone else added to it. Why would someone change a font in the size mid-sentence?
And here's the other thing to make note here. So that's that order there says on the court's own motion. There's no motion filed. So there's
my motion.
There's no
my petition.
The court. The court said they made that order based on their own motion, but they never filed a motion to explain why all of a sudden they changed their mind. Did they have evidence? Did something happen?
And then send it to me 21
days
later. 21 days after it's supposedly filed.
Well, there's a distinct reason for that, because if they waited long enough before they told you about it, you won't be able to arrange time off and transportation, and then they can just say, oh, she's not here, dismissed. And that's their plan.
They think I'm stupid. They really do. I'm pro se, so they think I'm stupid. And what they don't understand is I'm literally building my federal case right now.
It's really the dumbest.
This is my federal case.
As an outsider watching this, honestly, the dumbest thing this court is doing is letting this continue. The reality is Illinois law is such that they could have literally just received Heather's initial petition, looked at the docket, made a decision. There's no requirement to have a hearing. This is just the judge wanting to have a hearing. Mm-hmm. It's Illinois law says that when a petition for relief is presented, if it is valid, if all the facts are accurate, and stand on their own, the court is required to actually accept it and enforce it as such. But this is just the judges do have discretion to have hearings, which is what's happening here, and it's really just. The reality is this judge is just trying to drag this out.
What she doesn't understand is that I'm literally building my federal case against her right now.
Well, not only that, they're trying to drag it out, hoping Heather just disappears and goes away.
Not gonna happen.
The only thing that's happening is Heather's getting louder. Mm-hmm. I mean, we're on a podcast here.
And way more evidence is getting filed.
This video, when we're done, goes not only on Facebook, it goes up on YouTube. And then it goes out to every single podcast. Converted to an audio podcast, and it's on Audible, Spotify, Amazon Music, Apple Music, iHeartRadio, half dozen other ones.
It's on it. It's everywhere. It's everywhere. They can't hide from this.
And then
sorry.
And then you're getting involved in some other stuff too, where you're getting some national recognition, and more people are hearing about Heather's story, and more people are going to be looking into, the Illinois Circuit 19. It's just going to bring more and more attention to them. So the easiest thing they could have done, if they don't want this attention, what they should do,
give me my children,
just vacate the order. And then it disappears from Illinois Circuit 19. Everything gets kicked back to Florida Circuit 7, and then Florida Circuit 7 is the problem.
Yeah. Be the bigger bully, guys. Be the bigger bully. Words of Dave Weigel, very wise words. Be the bigger bully.
Heather doesn't like it because I'm very passive in a lot of things, and I have to be for my job. But I'm definitely seeing the value in, as Heather just said, being the bigger bully. I've talked with Dave Weigel. I've listened to him and several of his lives, and his attitude about how you have to what you have to actually do to win in the current family court system. You basically have to light it on fire, and I'm burn a pyro, it down. So. and because you can't play by the rules. The rules don't exist, and that's what so many people don't understand. People are trying to play by the rules. The rules don't exist.
No. They're playing a game of chess without actually following the rules of chess. Yeah. And they expect us, as pro se litigants, to 100% follow the rules. Yeah. So. And, like what I'm dealing with the Illinois Circuit 19 clerk's office.
So
Aaron Cartwright Weinstein. And every time I file something, it takes me 3 or 4 filings before it's accepted. And
it's weird because you actually know her. You grew up with her.
Yeah, yeah. So another one from Gurney. So now we have the family minutes from the September 2nd, very brief. Bendl Heather, petitioner present via video, attorney Will Traberis present via Zoom, blah, blah, blah.
And I can't help but notice on that, it doesn't say anything about them, court demanding them to be in person.
No.
So that didn't
And then it just says nature of proceedings, heard and continued September 2nd. This matter is set for hearing on October 8th, 2025 at 9 a.m. in courtroom 105.
And what time was that actually entered? What is there a timestamp on it?
It doesn't really. It just says event day, September 2nd, 9 a.m., which is when court started. But no, nothing other than that. All right. And so that then brings us to something that I had rejected 2 times before it finally got accepted today. With a timestamp of October 1st at 1:53 p.m.
Now,
Aaron Cartwright Weinstein. And it took me emailing the clerk's office to say, what the hell? Stop rejecting my stuff. You're rejecting it for false reasons. The first rejection said it was missing a emergency affidavit and a certificate. And then it was rejected a second time saying, you need to pay us $75.
So
I don't. I have an application for fee waiver on this case.
So here's the stupid and funny part about that affidavit for emergency, status or whatever it is. Okay. That's basically like they want you to write down on a separate piece of paper why this thing is an emergency, even though you've already written down in this why this is an emergency. They need you to write it a second time and file it with this.
It's supposedly a local rule, local to Circuit 19, I think. Probably because they want every reason possible to deny an emergency motion.
It just adds on to the inefficiency of the process. Now, when you first filed this particular motion, I was still in the hospital.
Yeah.
But
it was
you've
the
been making
28th.
an effort. You've been making an effort to have all of your filings in every court be verified, and verified just means that your identity has been confirmed.
Yeah. So
you need a notary to basically sign off on it. And luckily for you, I do hold a notary public in Florida.
So his name is all over all of my documents.
I don't use for anything but your documents at this point. So you actually got my stamp and drove up to the ER or up to the hospital just so I could actually legally notarize this. You could have in person. Hospital. You could have just stamped it on your own and forged my signature. Nobody would have known.
No, because I play by the rules. I don't want to break laws. I don't want to be a criminal. But these people that are holding my children hostage, Justin, Mary, and Ira Serlick, and the judges between Florida Circuit 7 and Illinois Circuit 19 are criminals. Flat out criminals. They're felons, what they're doing to my children and I. Felonies. They are committing felonies. But here's me literally playing by every single possible rule, even when I really don't have to. It's my conscience. I do not want anything on my conscience that I am doing wrong. I don't want anything to ever come back and bite me. So I am going to play by the rules and do everything legally because they are the criminals, not me. So this motion that I filed, verified emergency motion to 1, clarify and or vacate conflicting September 2nd orders, because we've got 2 orders just over an hour apart, one saying I can appear via Zoom, and then one saying my Zoom has been revoked, with no evidence as to why
and
my Zoom is revoked.
No explanation either. It's just the court saying, we decided we're going to just revoke her Zoom access and review future access.
So this is all just that verified emergency motion. I filed that on the 28th. It got kicked back and rejected because it was missing an emergency affidavit in support of verified emergency motion to clarify / vacate conflicting orders, reinstate Zoom access under Illinois Supreme Court Rule 45, and request ADA accommodations. So when they rejected it, they were stupid for rejecting it for that, because all it did was just give me more opportunity to get more shit on the record. So in this, I added, I suffer from a documented disability. I'm profoundly deaf in my right ear and experience chronic complex PTSD from the abuse this Illinois Circuit 19 court has inflicted upon my children and I since October 8th, 2020. These impairments affect my ability to safely and effectively attend court proceedings in person, particularly in echo-prone, crowded courtrooms. So this is touching on my hearing disability. I'm deaf in my right ear. I have trouble hearing in loud, echoey rooms.
You go into panic attacks.
I go into panic attacks because these people have been abusing my children and I since they kidnapped from their daycare.
I mean, and when you go into a panic attack, I mean, it quickly can turn into a medical emergency.
Yeah. So yeah, that's that. And then after that, I had to add a, I think I printed this twice, so I'll have to fix this. But I had to print a certificate petition to vacate modified judgment because this emergency motion has the word vacate in it. It's and or vacate, clarify and or vacate. Basically, I'm saying you better damn well vacate this second order from 3:07 p.m. that's ordering me to come in person because you're violating my rights.
Yeah, it's basically there's a fundamental principle in the legal system in the U.S. and it's due process, but it's also equal justice. Mm-hmm. And you can't say one party of a case has to appear in person, but the other they don't have to.
Well, why does Justin get special privileges? Because mommy Mary Serlick and stepdaddy Ira Serlick have connections to Michael G. Nurheim, an appointed judge in Circuit 19, who was the state attorney responsible for prosecuting Justin in 2020. And that never happened.
Responsible but did not prosecute.
That never happened. It was just quietly gone because my kids were kidnapped. So certificate petition to vacate, this is just a generic form you have to pull on their website.
Basically more stupid busy work.
More stupid paperwork, pushing papers.
I mean,
where you have to check on September 2nd, 2025, a non-final, non-appealable judgment or order was entered in this case, and I seek to vacate, modify that order. And that would be that September 2nd filing that is forcing me to come in person 1,800 miles away. And then because they kicked it back a second time after I filed the affidavit and the certificate, they then kicked it back a second time saying I needed to pay a $75 filing fee for the motion to vacate, when there was already an application for fee waiver of court fees on my file. It's sitting there. It's in my docket. When I filed the original petition to vacate in July. Unlike
Florida, Illinois, which Florida requires you to file an affidavit of indigency every single time you file something, Illinois doesn't. Once it's filed and on your, attached to your case,
it's a fee waiver for the case.
They don't continue to demand you file this.
So what I did, because I'm going to take every opportunity possible to get everything on the record. So fine, you're going to reject it a second time. I'm going to get more shit on the record. So in my application for waiver of application fees, I filed under hardship information optional, I typed up the following. It would be a substantial hardship for me and my family if I have to pay the fees, costs, and charges because, and then I begin with, I am $100,000 in debt because of what Illinois Circuit 19 has done to me since October 8th of 2020. $66,000 of that is attorney fees caused by this very court. $25,000 of it is storage fees caused by Justin Derek Serlick. Now, because of this court signing an illegal and fraudulent order April 27th, 2022, I am $33,000 in child support arrears while Justin Derek Serlick holds my 4 children hostage in Daytona, Florida, demanding ransom of $33,000 stemming from said fraudulent order, listing that I am to pay him $785 a month based on no financial affidavit but his expenditures. Like $400 a month in entertainment. That's part of the $785. That's what he wrote on his financial affidavit. He's paying $400 a month to entertain my children when I have gotten from the mouths of babes, Ariana Serlick and Charles Serlick flat out telling me
they don't do anything.
Dad doesn't do anything with us. He doesn't take us anywhere. We sit in our room and we play video games. Charlie doesn't even know how to swim, so he's not even taking him to the beach or the pool.
Didn't get the kids enrolled back in Scouts when they got down here.
Nope.
So the kids dropped out of
Scouts.
That was all
me. I was the Girl Scout. I have
No
always been
sports,
involved with Girl Scouts.
No athletics, no other activities.
When my children were with me, Ariana and Tommy were in cross country and track. They loved it. Tommy was in band. Tommy was in Cub Scouts, crossed over into Boy Scouts. Ariana was in Girl Scouts and BSA Scouts, as well as being a Girl Scout national delegate. Bianca was dual enrolled in Girl Scouts. I was a Girl Scout leader. And she was in Cub Scout Pack 179 that helped raise her. That was Tommy's pack. And then Charlie was about to begin as a Lion in Pack 179 right after this stuff began. And my children have lost all of their scouting ever since 2020 when they were stolen. So at the very bottom of this, I said, I will have to file bankruptcy because of what Illinois Circuit 19 has done to my children and I since October 8th, 2020. So... that's it for my docket.
So
but
then they accepted it.
They finally accepted it because I shot an email to Aaron Cartwright Weinstein saying, what the hell?
So here's the thing. They accepted that today, but the hearing is Wednesday.
Yeah.
So
less than a week.
The court, it's not like they're going to make any decision, Saturday or Sunday. So unless they miraculously actually look at that and make some sort of a decision tomorrow on Friday, by Monday, if there's no decision, we're looking at
gonna have to fly up to Chicago.
Probably another couple $1,000s just for plane tickets and a rental car.
Chicago. The area that kidnapped my children, child trafficked them for a year, so everybody can make money off of them, and then sold them to the non-custodial parents.
And to be specific, because you've mentioned the term sold, and I know a lot of people get upset with
Guardian
that term.
ad litem Kathleen McGee.
But when you say
how much
sold,
money did you make off my children?
Well, when you say sold, I just want to clarify for people out there why you're saying that. The reason you're saying that is because basically the court went off of a report from the guardian ad litem, who this guardian ad litem never met you, never spoke to you on the phone, nothing. But the way the reports are written, she clearly spoke to Justin. She spoke to Justin's family. She spoke to all the kids. And the only reason for that is they had money. They had been paying an expensive attorney who basically they were able to pay an attorney enough to file enough things to force the guardian ad litem to say, oh, we should send the kids to Florida. But they completely ignored Heather's rights as a parent, which have never been terminated. Were not terminated at that point.
Nope.
At that
my
point,
rights are reserved by this 3-page order.
Meaning just the court wasn't making a decision on Heather's rights at the time.
And the court shouldn't have made any decisions on that at the time. Because we were all Floridians at this point.
Part of Heather's argument why the actual order needs to be vacated, if you actually look at Illinois state law, the courts are not allowed to actually issue final orders not being definitive about both parents' rights. They can't just say it's literally in the laws. The court is not allowed to issue an order and make it a final order reserving a parent's rights. They have to make a decision, and that decision would be this parent's rights are terminated or they're not. And in Heather's case, that's the court didn't follow the state law. They just made up their own rules as they went, signed off on something because this law firm just emails stuff to judges and judges just sign it. Yep.
He literally just emailed that 3-page order to Judge Marnie Slavin.
Not filed in the docket before it was signed.
Nope. It was. I was not provided a copy of it. They literally ex parte signed off my rights to my own children to the non-custodial parent who has been holding them hostage for 4 years now since he's had them in his possession. So the same day that this finally gets accepted, October 1st, I get an email, a very generic email from Sarah Palmer from Katz Goldstein Warren, which is the original law firm that had pushed through that 3-page ex parte order April 27, 2022. And then they email me this 1-page on their letterhead that says via hand delivery to Honorable Jacqueline D. Melius with the date of October 1st in re the marriage of Bendl / Serlick, case number 20F422 13D981. Dear Judge Melius, the above referenced matter is scheduled for an in-person hearing before Your Honor on October 8th, 2025 at 9 a.m. per the court order entered on September 2nd, 2025. Enclosed, please find courtesy copies of Petitioner's verified petition for relief, Respondent's 2-count petition to strike and dismiss Petitioner's verified petition for relief. Thank you for your attention on this matter. Very truly yours, Katz, Goldstein, and Warren, Will Treberis.
And what was courteously not included with that was Heather's response to their motion to dismiss. Mm-hmm. So
yeah. So, there is Mary, Ira, and Justin's, I'm going to say Mary and Ira because there's no damn way that Justin's actually doing this. This is all his mommy and daddy. They want to keep everything off the record. And the more opportunities they give me to get things on the record, I'm going to do so. So I'm building my federal case.
That's where things are right now.
In Illinois.
And
quickly.
Now, we did do something this afternoon. So I did reach out to my cousin who lives in Chicago. My cousin was a paralegal, worked for some major companies in the city of Chicago. His wife is an attorney, does not in family law, but we did reach out to them to see if they had any referrals or recommendations. So they're, my cousin is checking through his circles. He did send us one name that we're going to reach out to already, but we might get something else here and see what we can do.
It's really hard after having 3 separate attorneys that have worked for the Serlicks the whole time while stealing $66,000. It's really hard to even consider trusting an attorney ever again.
However,
if it's someone that is absolutely recommended to me by a family member, that's another story. So we'll see. But here in Florida Circuit 7, as everyone is aware,
big change.
I organized a protest at the Daytona Courthouse and the Daytona District 5 Court of Appeals.
And this was part of a larger national protest that weekend. You were just sort of the local coordinator for the Daytona.
I coordinated Daytona, but this was a national protest for 3 days, the 9th, 10th, and 11th. So we and a few other victims in Daytona and Seminole County gathered together on that Sunday for at least 4 to 5 hours. We were out there pretty much all day.
It was a long day. I got cooked by the sun. I was red.
But then a week and a half ago, I got a message from one person that knew that I had up church and she had up church say, I think the protest worked. I'm like, what are you talking about? Upchurch is leaving Daytona. Huh?
Yeah.
Yeah, there's apparently she's telling the attorneys that she is no longer going to be on the cases because she's shifting over to Flagler County.
Yeah.
And so I didn't know what to think of that. I hadn't heard anything.
Then you got somebody else, second person.
I got another person that is a victim of Sandra C. Upchurch, then confirmed as well. I was told by an attorney that she is leaving. Okay, so that's 2 people confirming it.
And then, did you get a third? I can't remember.
I did not get a third, but then all of a sudden,
there's a news article.
Yeah, there is a news article. So I get that sent to me, and then I look at my Florida Circuit 7 clerk.org docket, and lo and behold, I no longer have Upchurch. Within 3 weeks of that Daytona protest, Upchurch is off my case.
Not only do you not have Upchurch for
none
a
of them
family
do.
Case, no, Upchurch is off family law.
Yep.
She's the article says she was moved to either probate or what was the other?
It has nothing to do with family law, though. She was taken completely off family law and removed from the Daytona courthouse and shifted to Flagler.
Yeah.
And who took over my case and the other cases is a newly appointed judge.
Former state attorney.
Mm-hmm.
So this person has never actually sat on the bench before.
Nope.
Which... good or bad, we don't know yet.
We don't know yet, but it'll be very hard for the Serlicks to sink their teeth into this judge and bribe this judge when she is brand new to the career. something tells me this brand new judge is not going to be wanting to engage in illegal activity with a case that's being exposed all over the nation.
You'd certainly hope that somebody who is a former state attorney, this was somebody who was a prosecutor in criminal court. You'd certainly hope that they would not themselves fall to
becoming a criminal. Yeah.
But you would take somebody who's, this is what people don't understand. Judges don't actually get training on whatever subject they're judging. They go to law school. Law school is very generic in general. It's more about constitutional law and history of cases and stuff like that. The actual procedures attorneys learn by sitting in court and watching court. And so every court's just making up their own shit. So attorneys are seeing different shit everywhere. When somebody gets appointed to be a judge, it's not like there's really like judge training. Like here are the rules when you're a judge. This is what you're supposed to do. So they just base it off of the prior experiences they've had working with judges.
Yeah. It's definitely going to be interesting. So we shall see where the Florida Circuit 7 case goes now. There are going to be some things filed by me, of course. And I already know what I'm going to be doing with that. But right now, I have to keep my focus on this Illinois case that I started. And I'm going to push it as far as I can because these criminals in the Waukegan courthouse will be getting served as defendants in federal cases at some point. Morosin, Lombardo, Slavin, Melius, all of them are going to be defendants.
I know you did want to keep this under an hour, so we're just over that now. But there was one other big thing that we forgot to mention. So in the 5th District Court of Appeal, Heather's first. So Heather, you've got 3 cases presently? 3
appeals total.
Three appeals running through the 5th District Court of Appeals. They're all on slightly different subjects. But in the first one, there's timelines. One party files their initial brief. The other party has a timeline to file a response brief.
Yeah. Justin Serlick never responded. So I filed into that case just a notice that he never responded and that I am requesting that the panel of judges move forward with that first appeal that I triggered back in April without his response.
Now, and basically, with the appeals court, it's very different than the trial court. The appeals court, they're just looking at the documents, right? So they're looking at what you file. They're reading what you file. They're reading what the other party files. They're looking at the actual court docket. So when you have, Heather filed her initial brief, it tells her story. Over here, you have Justin didn't file anything, so there's no defense. The court almost has to, side on Heather's side of things. You would think. They can.
Are they protecting Upchurch? I guess we'll find out.
I mean, and it's going to be interesting if they try to, not decide favorably on the appeal over some stupid asinine technical reason. Some ultra legal, complication.
Or it's just going to sit. I've been hearing a lot of people across the nation where their appeals just sit for 6 months.
Well, and that's the timeline. I don't know that there's actually an official deadline, but when you ask, the internet, how long do appeals take? They say, well, it can take up to 180 days for them. And that's 180 days from the last step. So we're at the point now, Heather's saying, okay, move forward. So potentially 6 months from now is when we might get a decision on it.
Yeah.
And in the intervening time, they might say, okay, we need oral arguments. We need you to come in and talk for 20 minutes.
And within that 6 months, my son turns 18 on October 29th. So there is child number 2 aged out. Ariana aged out last year, September 15th of 2024. Tommy is about to age out October 29th of this month. And that leaves me with 2 minor children out of 4 left because of what Illinois Circuit 19 has inflicted upon my children and I the last 5 years. So they have stolen their lives from them. But there is a second appeal that I just filed my initial brief on, is what he was about to get to.
Which you can check Heather's Facebook. It's, interesting little background story on that. I was in the hospital, but obviously, trying to help Heather out as much as I can. So I'm in the hospital on my laptop. Set in a Zoom, so we're talking back and forth, sharing screens. I've got a NG tube down my nose. I'm hooked up to PICC line with IV and IV nutrition coming in, and still trying to help Heather out with that.
That's
but we
dedication.
We got that one
fighting for children he hasn't even met yet.
We got that one filed. Well, no, I've met.
Well,
Charlie,
I'm referring to Bianca and
Yeah.
Tommy.
Yeah.
2 of the children you have not met yet. You met the oldest and the youngest. You have not met my middle 2.
So,
and that's by design, I'm sure, because my middle 2 are autistic and special needs, and there's definitely a reason they're keeping those 2 from me.
So.
It is very clear that they're taking advantage of their autism.
So I mean, we've covered the case, and we're going to be signing off here. Just anytime we get deep into stuff like this, we do like to end on a happy note. Mm-hmm. So we're just gonna, a couple good things that happened. I was able to get out of the hospital.
You broke free.
And on Tuesday, I was able to hold a ribbon cutting and open house at my new office. My company gave me my own office, so I'm excited about growing with that. And then that Tuesday night, we were able to go to the Tampa Bay Lightning versus Florida Predators preseason hockey game. So it was an exhibition game at the Kia Center in Orlando. They did one last year. We went to it last year. So we were able to have some fun with it. Obviously, it would have been funner if I wasn't completely in pain from the surgery. But
he got out of the hospital 24 hours before that game. So.
But we had fun with that, and then our last sort of celebratory thing this week. We're doing tomorrow, and this is your thing. This is we're.
Oh, come on! Okay, you can't say that she's not hot.
Part of
come on.
Part of it's.
You're going to be oogling. You're going to be looking at her on the screen.
We're getting the plan for tomorrow night is getting some Chicago style pizza, which I was given a gift card for, and then going to see Taylor Swift's movie premiere thing, whatever it is.
The Life of a Showgirl. Her album releases tonight at midnight, and she has a 3-day movie expedition that kind of gives the background of the album. And I'm a total Swiftie. I've been a Swiftie since the very beginning.
This was
watching that girl in Nashville.
Heather got tickets for that. So on the Saturday when I was first released from the hospital, basically Heather dumps me off at the house and then races back up to the theater to buy tickets.
Yep. I'm a Swiftie. I'm not an insane Swiftie that would spend $5,000 to go see her on the Eras tour in another country. Right. That is a whole nother level of Swiftie. But I did watch the lives constantly on Facebook while the Eras tour was happening. And the whole Taylor and Travis love story is, how much more romantic can you get?
So with that, anybody that's watching this, I know some of you are going through your own battles. Just make sure to celebrate your wins. Know that there's other people that do support you, that, there's other people that know what you're going through. That being said, I'm getting my podcast. I know we've said it so many times. Wasn't planning on spending almost 2 weeks in the hospital.
First it was your mother, then it was your aunt, then it was you. It's been a last 2 months of health issues in the family. We're
going to get, my plan is by the end of this next week, we'll get at least one new episode recorded from my podcast. My podcast is the Support Isn't Silent podcast. It tells the stories of people like me that are supporters of the victims of family court. And we've already got some people that had signed up on our interest form, so I'm going to be reaching out to them tomorrow.
Yep, we've got a Google form with a long list of guests that want to be on those podcasts, so we're going to be starting to reach out to them. And
then Heather's going to get her other podcast going, which is the Disrupt the Corrupt podcast, which is going to allow other victims of family court to tell their stories. It's just going to give them a platform to get their story on the record for the public to see. One thing we have definitely seen is the louder and more public both Heather and I become about telling Heather's story, the quieter some of the minions out there seem to get. And sometimes that's just what you have to do. Sometimes, you don't want to rock the boat, but sometimes you have to flip the boat over. And so...
Be the bigger bully.
So with that being said, thank you for watching. If you're listening to the podcast, thank you for listening. We appreciate your support as well, and we want to offer our support to you. So enjoy the weekend. Have some fun for yourself, no matter what's going on in your life. Take a break, have some fun, and enjoy life as much as you can.
I'm going to be enjoying 12 New Songs by Taylor Swift.
All right.
Have a great weekend,
Have a great
everyone.
night.
Bye.